Chapter 7. Subrogation under contracts of insurance. 221. Subrogation of marine insurers. Marine insurers acquire by the abandonment to them of the property insured, and by the satisfaction of their policies, all the ownership of the insured in the property abandoned, with the spes recuperandi, and all the rights and remedies of the insured with respect thereto, and may prosecute all subsequent rights and remedies in their own names, and the insurers may bring a libel to enforce this right even before their actual payment. And their payment of a total loss without the form of an abandonment will have the same effect. The law gives to the act of abandonment, when accepted, all the effects which the mote carefully drawn assignment would accomplish. By the act of abandonment, the insured renounces and yields up to the underwriter all his right, title, and claims to what may be saved, and leaves it to him to make the most of it for his own benefit. The underwriter then stands in the place of the insured, and becomes legally entitled to all that can be saved from destruction. The insurers are entitled, upon settlement as for a total loss, to be subrogated for their own benefit to any rights of action of the insured against a third party for his negligence or wrongdoing causing the loss. Nor can such third party in an action brought against him in the name of the insured set up the insurer's payment to the plaintiff as a defense, either wholly or pro tanto. The abandonment has a retroactive effect, and vests in the insurers the title to the property or its proceeds from the time of the injury or loss, as fully as if it had been the subject of a bill of sale. The property vests in the insurers with its benefits as well as its burdens, if the abandonment has been rightfully made, though the loss has not been actually paid. 222. Subrogation to the remedy for a tort causing the loss. Accordingly, the right of a shipowner to indemnity for an unjust capture will pass by his abandonment to the insurers of the ship, and on the latter's bankruptcy will vest in their assignees. The insurers of a ship which has been run down and sunk by the fault of another ship are, upon their payment of a total loss, subrogated to the right of the insured to recover therefor against the owners of the latter vessel, and will be entitled to any damages which the insured may have recovered from such owners. And if their policy was a valued one, their payment of this value will give to them the whole spes recuperandi and the right to the whole damages, though the insured vessel was in fact worth a larger sum than the valuation named in the policy, this valuation being conclusive between the insurers and the insured. Accordingly, the defendants in an action to recover for the damage done to the plaintiff's ship by a collision cannot deduct from the damages to be paid by them the amount that has been paid to the plaintiff for the same injury by insurers of the ship. The plaintiff is entitled to recover as to this amount as a trustee for the insurers. So too, if the insurers of goods have stipulated to answer for a loss by theft, and the master and shipowners are also liable for this loss, the insurers upon a loss by theft and an abandonment to them or their payment of a total loss will be entitled to be subrogated to the remedy of the insured therefor against the master and shipowners. And if the insured destroys this remedy after his recovery of judgment against the insurers, equity will relieve the latter pro tanto from this judgment. And as the master or ship owners would have no right to claim from owners of the goods contribution for such a loss, the policy cannot, upon their satisfying the insured, be legally assigned for their benefit, so as to enable them to recover from the insurers. Insurers will, upon satisfying a judgment recovered against them for the total loss of a vessel occasioned by the barratry of its master, be subrogated to the benefit of a judgment obtained by the insured against the master for the same loss, although they have, while the action against the master was pending, refused an offer of the insured to transfer the control of that action to them, upon condition that they should pay the expenses already incurred therein, and that the transfer should not prejudice any rights of the insured. 223. Limitations of this subrogation. This subrogation of the insurers to the remedy against a wrongdoer who has caused the loss which the insurers have satisfied is only to the remedies and rights of action which were vested in the insured or which the insured have succeeded in obtaining from the party at fault, subject to all the liabilities and duties which rested on the insured, even in favor of third parties. It is not an independent right of action in the insurers themselves, and will not be subject to any pers zero nal estoppel existing against the insurers in their own right. The insurers succeed merely to the means of redress, which were possessed by the party whom they have indemnified against the party whose wrongful act caused the loa accordingly, where two ships belonging to the same owner came into collision, and one of them sank and became a total loss. The insurers of the latter ship did not, upon their payment of a total loss, become entitled to make any claim for the loss against the insured as the owner of the ship at fault in the collision. For their right existed only through the owner of the ship insured, and not independently of him. And as he could not have sued himself, they would have no remedy against him. And the insurer's right of subrogation may be lost by their lashes in failing seasonably to enforce it before the rights of others have accrued. Nor will it be extended to cover a mere gift or gratuity subsequently received by the insured of what could not have been demanded as a right. 224. Do not arise upon a compromise of the insurer's liability. If the insurers do not accept an abandonment of the insured property or pay a total loss, but make a compromise of the claim upon them, they will not be subrogated to the rights of action of the insured for the wrongful act which caused the loss, or entitled to the compensation that may afterwards be realized therefor. Thus, where a cargo of merchandise which was insured was seized and condemned by the French government under the Berlin and Milan decrees, and a compromise was afterwards made between the underwriters and the insured, whereby the latter accepted from the former 1/3 of their claim under the policy and surrendered the policy, but did not cede or assign to the underwriters their claim to indemnity from the French government, it was held, on the underwriters subsequently receiving the amount of their payment as an indemnity from the French government, that they received this money in trust for the insured, could not hold it by subrogation, and must pay it over to them. And if, under such circumstances, the insured should, after their compromise with the underwriters, receive full compensation for their loss from the parties at fault therefor, the underwriters would not be entitled to any part of this compensation. 225. Effect of an abandonment. After an abandonment, if it is a legal one, or if it is accepted, the insurers stand in the place of the insured, and the former agents of the insured become the agents of the insurers. The master of the ship become the agent or servant of the insurers, and is answerable to them for his neglect or misconduct. The consignee of goods insured becomes by the abandonment the agent of the insurers, and his act, done in good faith, are at their risk and for their benefit. An agent appointed by the insured after a capture to prosecute his claim becomes, after an abandonment, the agent of the insurers, and such agent's receipt of the proceeds of a sale of the captured property will be deemed to be a receipt thereof by the insurers, who must look to the agent for the amount, and pay to the insured the full amount of the loss, without any deduction therefor. The wages of the crew, after an abandonment, will be chargeable to the insurers, not as insurers, but as owners of the ship. Any purchase made by the insured or his agents of the abandoned property, which has been paid for by the insurers, will be taken to have been made for the benefit of the insurers, and the insurers, as owners of the ship, will be entitled to its earnings, if any are made after the abandonment. But since the earnings of the ship up to the time of the abandonment belong to the insured as its owner, if the owner of ship and goods rightfully abandons both to the underwriters as for a total loss by perils insured against, and part of the goods are saved, the insurers as owners of the goods will be liable to the insured as owners of the ship for freight pro rata itineris until the abandonment. The freight earned before and after the abandonment will be apportioned, so as to give to each party, the insured and the insurers, the earnings of the ship during the respective periods of their ownership thereof. 226. Abandonment of ship and freight separately insured. If the owner of a ship has effected separate insurances upon ship and freight, and afterwards rightfully abandons both to the underwriters upon them respectively, the doctrine generally adopt in this country is that he is entitled to recover for a total loss of both, and that the freight earned prior to the loss goes to the ship owner, or to his representatives, the insurers of the freight, to whom it has been abandoned, while the freight, if any, earned subsequently to the loss which has caused the abandonment goes to the insurers of the ship, who have by the abandonment become its owners. The abandonment of the vessel to the insurers thereof will not preclude the insured from recovering upon the policy on the freight. Accordingly, if a shipowner, having insured the ship and the freight separately with two sets of insurers, upon a capture of the ship abandons the ship to the insurers of the ship and the freight to the insurers of the freight, and then takes from the insurers of the ship half of his claim in cash, and for the other half an assignment of their interest in the ship, he will be entitled to the freight which would otherwise have been theirs, and may recover from the insurers of the freight to the full amount of their policy, deducting only the pro rata freight which had been earned before the abandonment. 227. English Doctrine. In England, as in the United States, freight earned subsequently to the loss by reason of which the abandonment is made goes to the insurers as owners of the ship. If after the disaster and abandonment, the cargo is transshipped and carried by another vessel to the port of destination, and the freight is thus earned, this will not be for the benefit of the insurers of the ship, nor will they be entitled to damages for the loss of this freight from a wrongdoer who has caused such loss. But if, after the loss which is the cause of the abandonment, the original ship proceeds on her voyage, and earns the pending freight, both the vessel and the freight being separately insured, the title to the whole freight is vested by the abandonment in the insurers of the ship. And the freight having been earned in accordance with a true interpretation of the policy upon the freight, and having been prevented from coming to the insured only by reason of his voluntary abandonment of the ship, the insured cannot recover anything in an action upon the latter policy. The abandonment produces the same results upon the title to the freight as would follow from any other transfer of the ship. 228. Subrogation of insurers on freight against the insured. If, however, the rights of the insurers of the freight are not complicated by the effect of an abandonment of the ship to the insurers thereof, their right of subrogation upon the abandonment to them of the insured subject will, as against the insured, be the same as that of other marine insurers. And however the question of priority of title as to the freight money might be held as between the two sets of insurers, and however the weight of argument might be taken to preponderate in favor of the underwriters upon the ship over those upon the freight, yet the title of the latter is superior to that of the insured claiming in his own right. 229. Subrogation against a carrier of insured goods. As between a carrier and an insurer of the same goods, the primary responsibility for their loss or destruction is upon the carrier, and the liability of the insurer is merely secondary, the owner and the insurer being considered as but one person, and having together the beneficial right to the indemnity due from the carrier for his breach of contract or non-performance of duty. Nor can the canier raise the question whether the insurers were bound under the policy to indemnify the insured for the loss sustained. If the insured, by his act and contrary to the terms of the policy, defeats this right of the insurers to be subrogated, the insurer's liability will be terminated. Standing, as the insurer does, practically in the position of a surety, stipulating that the goods shall not be destroyed or injured in consequence of the perils insured against, whenever he has indemnified the owner for the loss he is entitled to all the means of indemnity which the satisfied owner held against the party primarily liable. It is the doctrine of subrogation, dependent not at all upon privity of contract, but worked out through the right of the creditor or owner. Hence it has been often ruled that an insurer who has paid a loss may use the name of the insured in an action to obtain redress from the carrier whose failure of duty caused the loss. It is conceded that this doctrine prevail in cases of marine insurance, but it is denied that it is applicable to queues of fire insurance upon land. And the reason for the supposed difference is said to be that the insurer in a marine policy becomes the owner of the lost or injured property by the abandonment of the insured, while in land policies there can be no abandonment. But it is a mistake to suppose that the right of insurers in marine policies to proceed against a carrier of goods after they have paid a total loss grows wholly, or even principally out of any abandonment. There can be no abandonment where there has been total destruction. There is nothing upon which it can operate, and an insured party may recover for a total loss without it. It is laid down in Phillips on insurance that the payment of a loss, whether partial or total, gives the insurers an equitable title to what may afterwards be recovered from other parties on account of the loss, and that the effect of a payment of a loss is equivalent in this respect to that of an abandonment. There is then no reason for the subrogation of insurers by marine policies to the rights of action of the insured against a carrier by sea, which does not exist in support of a like subrogation in cases of insurance against fire upon land, nor do the authorities make any distinction between the cases. A marine insurer in such a case may in admiralty bring a libel against the carrier in his own name, but at law the remedy of fire insurers against the carrier must be pursued in the name of the insured, and is subject to all defenses which might be made against the insured. And the carrier may destroy the insurer's right by stipulating with the owner of the goods for the benefit of any insurance to be obtained by the owner against loss or damage to the goods for which the carrier would be liable. But the provision in a bill of lading that no damage that can be insured against will be paid for is but such a stipulation, and will not affect the rights of the insurer, which are not to be taken away by implication. Nor will the insurers be subrogated to any right of action which the insured may have against a third party for a breach of the latter's agreement to carry insurance on the property. 280. Insurer against fire subrogated to remedy against railroad. The insurers against fire of property which has been destroyed by fire communicated from a locomotive engine will, upon payment for the loss, be subrogated, to the extent of their payment, to the remedies of the insured, as the owners of the property insured and destroyed, against the railroad company for the loss. But this remedy must also, like that against a carrier, be prosecuted at law in the name of the insured, since the right of action was already vested in the latter before the payment by the insurers, except under those reformed codes of procedure which permit any action to be brought in the name of the real party in interest. But since the insurers take by subrogation only the rights of the insured, and the action for a single tort is indivisible, a judgment against a railroad company for the destruction of one building by fire, communicated from its locomotive engine, will bar another action in the name of the same plaintiff against the same defendant for the destruction of another building by fire communicated from the first building, although the second action is really brought and prosecuted for the benefit of an insurance company, which has, upon one of its policies, paid the plaintiff for the loss of the second building. A release given by the nominal plaintiff pending the action will not be a bar to its further prosecution against the railroad company for the benefit of the insurance company. Insurers of a building which has been destroyed by fire through the fault of a railroad company may restrain the insured from collecting or settling their claim against the railroad company without subrogation of the insurers, if before the payment by the insurance company of the amount due. Upon its policy, the owner of the property has received from the railroad company the amount of the loss above the insurance, and has given to the railroad company a discharge of its liability containing the statement that it was not intended thereby to release the insurance company from its liability to him. This will be treated as a limitation of the discharge to the amount of the loss over the insurance, retaining the claim upon the insurance company and reserving its remedy over, and so not barring the insurance company's right of subrogation against the railroad company. 231. Mode of enforcing this right. This subject was fully discussed in New Jersey, and it was determined that where an insurance company pays the insured for a loss by fire occasioned by the fault of a railroad company, and the insured afterwards receives from the railroad company the amount in satisfaction of his damages, he holds this in trust for the insurers, and they may recover it from him by a suit in equity. And if the railroad company has not paid the insured his damages, or has paid them knowing that the insured has already received his payment from the insurance company, the latter may maintain a suit at law against the railroad company in the name of the insured, even against his consent, to compel repayment of the damages to the amount of their payment. And a release given by the insured to the railroad company would be no defense to this suit. But these two remedies cannot be pursued on a single bill in equity. Neither the insured nor the railroad company is a necessary party to the suit against the other. They are not jointly liable, and no judgment could be rendered or decree made against both. The insurers may, however, before beginning their suit against the railroad company, bring a bill in equity to have a release given by the insured to the railroad company, when the latter knew of the payment by the insurers, declared void as a fraud upon their rights. And to this bill both the insured and the railroad company would be proper parties. 232. Subrogation against other parties liable for a loss by fire. In like manner, the insurers of a building, which has been burned in such a manner as to create a liability therefor in a municipality or in other parties at fault, cannot, upon their payment of a loss, maintain in their own names an action therefor against the parties ultimately responsible for the loss, but may do so in the names of the insured owners of the property whom they have indemnified. The insurer takes by substitution all the rights and remedies of the insured, and under some of the reformed codes of procedure, though not at common law, may after full payment maintain action thereon in their own names. The payment by the insurers will be no defense in an action brought by the owner of the property against the party who is answerable for the loss, either in bar of the action or in mitigation of damages. The insurer's payment gives them by subrogation an equitable interest in the claim against the wrongdoer. But this subrogation of the insurers is strictly limited to the existing rights of the insured, and is subject to the right of the owner to be fully compensated for the loss of his property. If he has obtained a partial indemnity from a municipality whose liability is less extensive than that of the insurers, this will be a defense only pro tanto to the insurers. They will still be liable to him within the limits of their policy for the amount of his loss, deducting therefrom the net proceeds of his recovery against the municipality, and if the insured owner of the property, after receiving payment of the insurance, is fully indemnified for his loss by the wrongdoer or from the latter's means, he must then account to the insurers for what they had previously paid him. The insurer's liability is merely a secondary one. On the same principle, where a building which was insured against fire, but not to its full value, had been burned through the fault of a municipality, and the owner had brought an action therefore against the municipality, and undertook to sue for the whole damage, as he may do, he was allowed to conduct the action without the interference of the insurers, though he would be liable to the insurers for anything that he might do in violation of his equitable duty towards them. So he could release the wrongdoer from liability for any injuries not covered by the insurance. By the civil law as adopted in Canada, the subrogation of the insurers is more extensive than has been already stated, and though liable for and paying only a part of the damage done, they may be subrogated pro tanto to the remedy of the insured against the wrongdoer who has caused the loss, and may thereupon maintain a suit in their own names for the recovery of their payment from such wrongdoer. 233. Subrogation of mortgagee to insurance procured by mortgager. A mortgagee as such has no claim to the benefit of a policy of insurance procured upon the mortgaged property by and for the mortgager, and the same is the case with the holder of a mechanic's lien. But an agreement, expressed or implied, on the part of the mortgager, that he will keep the mortgaged premises insured for the protection of the mortgagee, will create an equitable lien upon the money due for a loss, though the policy was procured by the mortgager in his own name upon the mortgaged property. And whether the policy existed at the time of the mortgage, or was afterwards taken out by the mortgager, although by a clause in the condition of the mortgage, the mortgagee was permitted, upon the mortgager's default, himself to take out a policy for his protection at the expense of the mortgager, adding any premiums that he might pay to the mortgage debt. And this equitable lien of the mortgagee will avail against both the insurance company and an assignee of the policy, if they were prior to the assignment notified of the rights of the mortgagee. And this lien in favor of the mortgagee upon insurance procured by the mortgager will be valid against the latter's assignee in bankruptcy. If in such a case a suit at law to recover the loss under the policy is pending between the legal owner of the policy and the insurance company, equity will not enjoin the further prosecution of this suit, but will, to avoid delay and expense and ascertain the rights of the parties, allow the suit to proceed to judgment, enjoining, however, the company from making payment to the plaintiff in that suit, and the plaintiff from receiving such payment, and allowing the mortgagee to appear and prosecute the suit, for the protection of his equitable lien upon the loss contested in it. If the mortgager's covenant was to keep the buildings insured, and in case of loss to apply the insurance money to rebuilding, and after a loss the mortgagee has sold the land under his mortgage for less than is due upon the mortgage debt, he will still be entitled to his equitable lien upon the insurance money for the balance due to him, although he has by his sale made rebuilding by the mortgager or his representatives impossible. But the mortgagee cannot hold the insurers liable for the amount of a loss under such a policy which they have paid to the mortgager before they bade notice of the terms of the mortgage. 234. Where a creditor obtains insurance upon property on which he has a lien. Where a creditor effects insurance upon property mortgaged or pledged to him to secure the payment of his demand, the insurers do not become sureties for the debt, nor do they acquire all the rights of such sureties. They are insurers of the particular property only, and so long as the property remains liable for the debt, so long its destruction by fire will be a loss to the creditor within the terms of the policy. Accordingly, it has been held in Massachusetts that a mortgagee who has, at his own expense, insured his interest in the mortgaged property against loss by fire may, in case of such a loss before he has received payment of his demand, collect the amount of the loss from the insurers for his own use, without first assigning the mortgage or any interest therein to the insurers. Nor can the insurers, upon offering to pay the loss and the additional amount due upon the mortgage above the loss, require the mortgage to be assigned to them, and thus be subrogated to the rights and remedies of the insured under his mortgage. But this Massachusetts rule has not been generally followed elsewhere. And in New Jersey, the insurers will, in such a case, upon their payment of the loss, be subrogated pro tanto to the benefit of the mortgage or other security held by the insured, and by paying to the insured the whole amount of the claim for which the latter holds his securities, they will become entitled to all such securities. And if after effecting the insurance the insured has parted with any of his securities or received partial payment of the debt for which they are held, and which gives him his insurable interest, the liability of the insurers will be proportionally diminished, unless the insurance was really intended for the benefit of the debtor. 235. Rights of mortgage in insurance obtained by mortgage. A mortgagor is not entitled to the benefit of insurance in the mortgaged property obtained by the mortgagee in his own name, at his own expense, and without the privity of the mortgagor, and in the event of a loss cannot require the amount received by the mortgagee upon such insurance to be applied in reduction of the mortgage debt. The interests of the mortgagee and of the mortgagor, though both insurable, are separate and distinct from each other. But if the mortgagee has procured the insurance, though in his own name, at the request and expense, and for the benefit of the mortgagor, as well as for his own protection, though this is by a parole agreement unknown to the insurers, the mortgagor will have the right, in case of a loss, to have the avails of the policy applied for his relief towards the discharge of his indebtedness. So, if the owner of land, after executing an agreement for its sale, but before making a conveyance, insures the buildings standing upon the land, and not merely the purchase money agreed to be paid to him, he may upon a loss recover the whole amount of the insurance, and will hold any surplus over the balance, the purchase money due to him in trust for the vendee of the premises. And the insurance company will have no right of subrogation to his claim upon the vendee for such purchase money. Where the owners of real estate, holding insurance against the loss of the buildings by fire, assigned the policy to a mortgagee of the estate, and a loss having occurred, the assignee brought suit upon the policy in the name of the insured, and obtained judgment thereon, and then, instead of collecting this judgment, coerced the payment from the insured by a foreclosure of his mortgage, the insured was held to be entitled to the benefit of this judgment, although, while the assignee held the policy, he had effected other insurance upon the property without notice to the insurers. 236. Insurance obtained by mortgagor for benefit of the mortgagee. If the owner of an equity of redemption has procured insurance upon the buildings standing on the mortgaged premises, payable in case of loss to the mortgagee as additional security to the latter, it is the right of the former to have the proceeds of the policy, in case of a loss, applied to the payment of the mortgage debt. Nor will this right be affected by the fact that the policy contains stipulation that no conveyance of the property shall affect the right of the mortgagee to recover for a loss. But if, after the issuing of such a policy, the equity of redemption is sold and conveyed, and a loss then occurs, and the insurance company, upon paying the amount of this loss to the mortgagee, takes from him an assignment of the mortgage and of the policy, the purchaser of the equity of redemption may redeem from the mortgage by paying to the insurance company as assignee of the mortgage the amount remaining due upon the mortgage debt, after deducting therefrom the payment received by the mortgagee from the company. An action at law upon a policy insuring the mortgagor, but made payable in case of loss to the mortgagee, and remaining in force for the protection of both, may be maintained in the name of either of them, though it has been intimated that the consent of the mortgagee is necessary to the maintenance of an action upon such a policy by the mortgagor in his own name. So long as the mortgagee is unsatisfied, he has the right to keep the control of such an action, and to receive the avails thereof. 237. where the policy stipulates for the subrogation of the insurers. A policy of insurance taken out by the mortgagor or the owner of the equity of redemption, and made payable in case of loss to the mortgagee, which, besides a stipulation that a forfeiture as to the mortgagor shall not affect the right of the mortgagee to recover for a loss, contains also the provision that, in case of the payment to the mortgagee of a loss for which the insurers would not be liable to the mortgagor, the insurers shall be subrogated to the rights of the mortgagee, and entitled to an assignment of the mortgage is not available to the mortgagor after a forfeiture of his right under the policy. And upon the payment of such a loss by the insurers to the mortgagee, they may take an assignment of the mortgage and collect from the mortgagor the whole amount of the debt secured thereby. If the mortgagee has destroyed the insurer's right of subrogation to the mortgage, he can no longer hold the insurers liable upon the policy. The same rule will be applied to a policy of insurance procured by a mortgagor and made payable in case of loss to a mortgagee, which has become forfeited by its terms, but which has been kept alive as to the mortgagee by an agreement between him and the insurers that his interests shall be absolutely insured, and that the insurers may be subrogated to his rights upon their payment to him of a loss, is the policy become avoided as to the mortgagor. This stipulation for the benefit of the mortgagee, though contained in a policy issued to the mortgagor, is an independent agreement between the insurers and the mortgagee, which is binding upon them, but with which the mortgagor has no concern. And if the mortgagee has himself insured his interest as such by a policy providing that upon the payment to him of a loss he shall assign his mortgage to the insurers, they will, upon paying to him the amount of a loss and taking an assignment of his mortgage, be entitled to all his original rights under the mortgage for the whole of the debt secured thereby. But the mortgagee's debt must be paid in full before the insurers can compel him to make over to them any share or proportion in the mortgage or the mortgage debt. 238. Between lessor and lessee or vendor and purchaser. If the lessee of buildings has by the terms of his lease the option to purchase them, and they are insured for the benefit of the lessee cannot, after the buildings have been burned, and the lessor has received the amount of his insurance require, by then exercising his option to purchase, the insurance money to be applied towards the satisfaction of his purchase money and the arrears of his rent. But if the insurance was procured by the lessee in accordance with his agreement, and for his benefit after exercising his option to purchase, he will, upon the exercise of this option after the occurrence of a loss, be entitled to the benefit of such insurance. In one case, it appeared that a lessee had by the terms of his lease the option of purchasing the leased premises for a stipulated price by giving certain notice of his intention to do so. The lessor covenanted to insure and did insure. The buildings were burned down, and the lessor received the insurance money. The lessee then gave seasonable notice of his intention to purchase and claimed the benefit of the insurance money as part payment of the stipulated price. But the lease containing no provision as to the disposition of the insurance money, it was held that the lessee was not entitled to it. If in such a case the purchase is completed after the insurers have paid to the vendor the amount of the loss, and the vendor receives from the purchaser the full amount of the agreed price without any abatement for the loss of the buildings destroyed, the insurers may by subrogation claim from the insured vendor the full benefit of the salvage that he has thus received from the purchaser, and so recover back from him the amount of the loss which they have previously paid him. The tenant has no interest in insurance procured for the benefit of the landlord, just as the landlord has no equitable claim upon the tenant's insurance of his own interest, and just as vendor and vendee have respectively no equitable claim upon insurance procured by either upon his own interest, unless by agreement between them, such as a provision that any money received upon the policy shall be applied to repair the injury. 289. Subrogation of life insurers. The doctrine of subrogation of the insurer has no application to an ordinary contract of life insurance, though this is probably because a contract of life insurance is not, like other insurance, a contract of indemnity merely, and it cannot be supposed to have been contemplated by the contracting parties that the insurer should be subrogated to the remedy of the insured for any wrong or injury which might cause a loss. Accordingly, where a railroad company has by its negligence caused the death of a passenger upon its road, Insurers who have thereby been compelled to pay a policy of insurance issued by them upon his life cannot maintain an action against the railroad company for the reimbursement of such payment. For though the loss of the insurers was caused by the railroad company's wrongful acts, yet as these wrongful acts affected the insurers only by reason of their artificial contractual relation with the insured to whom the wrong was done, their loss is too remote and indirect a consequence of the wrong to be the foundation of an action. Nor can the railroad company set up the insurance in diminution of the damages for which it is liable, unless so provided by the statute creating the liability. But, as has been already intimated, these decisions might perhaps better be sustained by the apparent fact that no subrogation of the insurers could have been intended by the parties to this insurance than upon the reasons assigned by the court. For it has already been shown that the doctrine of subrogation is wholly independent of any privity or contractual relations between the parties to be affected by it. And in almost all cases of the subrogation of marine or fire insurers to the remedies of the insured against a wrongdoer whose tort has caused the loss, this tort has affected the insurers only by reason of their artificial contractual relations with the insured to whom the wrong was done. But in these cases the subrogation of the insurers is contemplated, or must be presumed to have been contemplated, by the parties to the contract of insurance, since otherwise the insured would, contrary to the intent of the parties, receive more than an indemnity for the loss, or else the mere wrongdoer, the party primarily liable for the injury, would obtain the benefit of the insurer's subsidiary liability, a result which would be at variance with the principles of manifest justice from which the equitable doctrine of subrogation has been evolved. The payment by a life insurance company to a creditor of the amount of an insurance policy issued by it to him upon the life of his debtor is not pro tanto a satisfaction of the debt, unless the premiums have been paid by or for the debtor. If the debtor pays off the indebtedness in his lifetime, he cannot require from the creditor an assignment of such a policy, unless it was really obtained for him or at his expense. One who, not being the owner of a policy of insurance, has paid the premiums thereon, will not by substitution to the rights of the owner be entitled to a lien thereon, unless by reason of a contract with the owner, or by reason of the right of a trustee to indemnity out of the trust property for money expended by him in its preservation, or the right of a mortgagee to hold his lien for any money paid by him for the preservation of the property, or by the subrogation to the rights of such a mortgagee or trustee of one who has made such advances at their request and in their right.